Executive Editor News, joining us from the Mumbai newsroom with that copy of the judgment. Niranjan, over to you. Take us through the details of that judgment order that we have now accessed. What are the big takeaways?
Shravan, going to the detailed judgment. This is in the High Court of Justice, King's Bench Divisional Court of the UK, the Royal Courts of Justice. Lord Justice Stuart Smith, Mr. Justice J, between Nirav Modi and the Government of India. Nirav Modi versus the Government of India, playing out in the UK court. Exclusive copy of the judgment as delivered. This it's the approved judgment, and it says judgment was handed down remotely at 9:30 a.m. this morning by circulation to the parties. And thereafter, I'm going to read out the details of what the judgment reads out. It says, Nirav Deepak Modi is sought by the Government of India. There are 3 sets of criminal proceedings. The first, brought by the CBI, the Central Bureau of Investigation, relates to a fraud by the Punjab National Bank, which caused losses equivalent to over £700 million. The second, brought by the Enforcement Directorate, relating to the alleged laundering of the proceeds of that fraud. The Government of India submitted request for Modi's extradition into 2018. So 4 years later. 4 years later, it's happened, and I'm going to the effective part right now. I'm going to the effective part where you know the court gets into details and the procedural developments of the case. The district judge gave a lengthy and thorough judgment on a range of issues, most of which have fallen away in light of Nirav Modi's lawyer, and they go on to detail out everything that they have argued in court in the last few years. Shravan, let me go to the operative part. Just bear with me. And in this operative part, here it is. They say that in the light of our conclusion, we can address the judgment of the district judge shortly. He was conscious that the evidence before him was in some respects limited, and it may be said that his decision to proceed to the judgment without requiring further assurances from the Government of India at that point was bold at the point of being unwise. Furthermore, his apparent treatment of the absence of any immediate suicidal intentions, ideations, as determinative was for the reasons we have explained about the significance of future prognosis incorrect, which means they really rejected, trashed his argument that he was mentally unwell, he was suffering from mental ill health. To that extent, we would accept that there were grounds for challenging his reasoning. His conclusion, however, was sound. It may be that the main benefit of the appeal has been to obtain the extensive further assurances that we've identified in the course of this judgment. And they really, basically, we just wanted him to be sent back to India. I have the full details of the judgment here. And in this particular point, they go on to sort of completely trash his argument about it being oppressive to be sent back. The starting point is that a high threshold has to be reached in order to satisfy the court that Modi's condition is such that it would be oppressive to extradite him. So the court goes into great detail, Shravan. It's a 37-page order. We'll put it up on republicworld.com as well. But back to you for now, as you get us more details on the case itself, on what the agencies did to ensure that Nirav Modi was pinned and brought back. Shravan.
Well, in fact, Niranjan, perhaps you could also take a look at the other operative parts. Meanwhile, let me also bring in our colleague, Senior Executive Editor Abhishek Kapoor, and Tanisha is also going to join us from the Bharat newsroom. Abhishek, if I can just come to you. Niranjan has been able to identify some of the operative parts, but what's very interesting, and perhaps everyone needs to know, that what really worked in the favor of India, because a lot of questions essentially were being raised as far as the extradition process of Vijay Mallya is concerned. The difference, the stark difference being in this particular case, that they have been able to keep Nirav Modi behind bars from the very day that he was arrested.
Yeah, that's very true. That's very true, Shravan. And that's something to do with the kind of meticulous documentation that has been done by the agencies, ably supported by legislation. Remember, the Fugitive Economic Offenders Act became a law in India in 2018 after Nirav Modi and Vijay Mallya and Mehul Choksi, and in fact even Bhandari, I believe they had run away, and a suitable legislation had to be brought. Having said that, Nirav Modi still has one appeal, but besides that, the British are typically very notorious when it comes to extradition. For example, in India's experience over the last almost 3 decades, 1993 is the time we signed an extradition treaty with them, and of the 30-odd requests that have been made to the British for extradition. One or two have been addressed, or perhaps three max. And that really gives you an idea of the scale of difficulty that still remains. For example, in the case of Vijay Mallya, apart from the extradition proceedings, he has also started a political asylum proceeding in the UK, and that's going to take its own time, even if the British system really wants these fugitives to be extradited. Also, Shravan, remember that I'm giving you the political aspect for understanding. Even if some elements within the British system, for example, the earlier Home Secretary Preeti Patel, she wanted these proceedings to be fast-tracked, but then there was resistance from within the system. In fact, one aspect on which the foreign trade agreement, or free trade agreement, I beg your pardon, between India and the UK is stuck is the mobility argument, which includes extradition elements. So in that sense, I think still some distance to cover before Nirav Modi or the likes of Vijay Mallya can be brought back and submitted to due process of law. But this still is success for our agencies and the meticulous paperwork that has been done, which has satisfied both the Magistrates Court and now the High Court of the United Kingdom. Of course, there is one more appeal to the Supreme Court, which would go and the process that would be followed. Shravan.